खत्म हो जाएगा। अब ये पीपीटी शेयर कर रहे हैं।
विजिबल है मेरा स्क्रीन?
हाँ, स्क्रीन विजिबल है, पर वो जो आर ग्लास बनता है ना, उसे दबा दोगे तो बाकी चीजें आनी बंद हो जाएंगी।
I could not see my screen इसलिए।
नहीं, दिख रहा है। या आप देखोगे लेफ्ट साइड पहले सारे पीपीटी साथ साथ दिख रहे हैं, तो नीचे आर ग्लास होगा, उसे दबाओगे तो फिर बंद हो जाएगा।
अभी ठीक दिख रहा है?
नहीं, वही वाला इशू आ रहा है। चलो कोई नहीं, अब क्या करें, नहीं वो ठीक है, कल आ जाओ 10 बजे। 10 बजे चल, अब ये ऑन कर दे, यूट्यूब कर दे लाइव। Good evening, friends. Amongst us, we have Sanjeev, G.R. Srikanth, General Counsel of the RP Sanjeev Goenka Group. And we had earlier done a session with him on food safety. And that session is doing actually very well. And that was a very niche topic. Again, today topic is very niche in respect of understanding the corporate due diligence. We are thankful that Mr. G.R. Srikanth, the Group General Counsel, has agreed to share his knowledge. His PPTs will be uploaded on the website of Beyond Law. Thank you, Mr. Srikanth, for accepting our invite. Over to you.
Thank you, sir. Thank you for this opportunity. And good evening, everyone. First of all, thanks for joining us on this weekend. And when Vikasji told that we'll conduct a session, I thought that I had taken this topic of corporate due diligence. Why corporate due diligence? Because we know many of the people, many of the process deals where due diligence fails. Why it fails and all. This is a very interesting topic, especially in the corporate field. The due diligence forms the important part. Fortunately, unfortunately, this is not been told as a part of the curriculum in the law schools. So it's an opportunity that we can have a understanding or discussion on how it works, what are the basic things need to be considered, and what are the areas especially. I'll tell them the practical purpose, what the area need to look. And kindly note whatever I am expressing, these are my personal views. So first of all, understanding what is due diligence. Due diligence, in simple words, it's stating that it's a investigation into the company's either a legal history or contracts or disputes or litigations. So we know that the company has different functions, be it an HR, IT, operations, legal, finance, all these operations. So whenever you are conducting a due diligence, why will conduct a due diligence? I'll give a simple example. Imagine if you are buying a car, especially if you are buying a used car, you generally make 10 parameters to check what is the service history and what is the accident record, how much is the mileage is giving, what is the number of kilometers it's already traveled, who is the ownership, either there is any penalties are there or not. So you'll do all these kind of, even for simple buying a used car, you do the same thing. Similarly, if you're buying nowadays, whatever you're buying online, first and foremost thing what you'll do, you'll see a reviews. What is the review? There's a good, excellent, or average, bad. You make a decision. Similarly, in any corporate world, if you are acquiring a property, you are acquiring a company, or acquiring some asset, you conduct certain diligence. Again, what is a diligence? Diligence is nothing but it's not a superlative intelligence. It's a man of who the man of ordinary prudence, what he can conceal and what he can discover the thing over the process of investigation. That is the diligence. So when coming to the legal due diligence is a process. If I put in the definition, of course, this is not a defined definition in some black law dictionary or somewhere, but general sense. Legal diligence is the process of investigating a company's legal history, investigating company contracts, investigating other functions of the company. Why? Either it's for a purpose of a merger, or for the purpose of an acquisition or purpose of an investment. So these are the basic outline or understanding of conducting a due diligence. As I mentioned here that it's due if you're conducting any project or undertaking any acquisition or investment without diligence, it's like signing a contract blindly without reading it. So when we say that due diligence, there are many areas, many branches of due diligence we need to conduct for acquisition. I'll give here an example, keeping in mind that it's kind of an acquisition. So we are acquiring either an asset, either a company. Keeping that in mind, I'll next 20-30 minutes, I'll talk on these lines. So what is that? There are different types of corporate due diligence. What are they? You have first and foremost the financial due diligence. Financial due diligence, basically, in case of an acquisition, you conduct a thorough financial due diligence, inquiring into the balance sheet for last 3 years, 6 years, depend upon the nature of the company, looking at their finance working capital, looking at the borrowings, looking at if it's a listed company, looking at the various types of compliances, if it is a type of corporate structures. So these kind of financial appraisal we'll do while conducting a financial due diligence. Most importantly, what are the revenue streams and what is the short term debts, long term debts, and these will be appraised in the process of due diligence. This is a financial due diligence. Another is the operational due diligence. Operational is what is the process, if it is a manufacturing unit, what is the efficiency, PLF, plant load factor, what is the capacity and what is the capacity being utilized, is the scope for increasing the capacity, and what is the practices and what are the systems. So these are all covered under operational due diligence. Similarly, in case of human resource, there's a separate due diligence is required, because entire any company or any industry which primarily works on the manpower is the one of the main assets. So what is the number of employees and what is the age of the employees, what is the experience of the employees, whether senior employees are going to retire. Because in one of the acquisitions, what it is observed that the average age of the employees is very high, because in case of early retirement or is retirement on account of superannuation, you need to hire the entire team. So it's again a process of investment. So these type of parameters you need to consider. And if it is a labor oriented industry, then what is the, if it is unionized or if it is unionized, what are the terms and conditions of the union agreements and when it's going to renew. So these all we need to keep. Apart from this, other HR related policies, be it be it on post related or be it on equal employment opportunities and other labor codes, the compliances. And again if you're talking about compliances, again discharge of statutory liabilities like provident fund, ESI, those we all need to consider this. Then another area of conducting is tax due diligence. So what are the taxes? Because any industries, whether it's you have a direct or indirect taxation application, so you need to conduct a compliances about the taxes. So these are the many areas. We have environmental, we have the commercial. So currently we discuss about legal due diligence. So among all these due diligence areas of due diligence, now we'll discuss only about legal due diligence. So what is legal due diligence? So it's about reviewing your contracts, it's about reviewing your dispute analysis, is about your litigation, it's about statutory compliances. What are the compliances the company is being followed? First of all, why we need to conduct legal due diligence? Because we need to ascertain what are the hidden legal risks and what are the claims against the company and what are the assets, whether intellectual properties, real properties, and what are the liabilities and what are the threatened legal disputes and what are the actual filed legal disputes. So in order to have this entire thing, we need to conduct a thorough legal due diligence. I'll give an example. In 2016, Verizon has acquired Yahoo Inc. So during the process, there was a consideration was somewhere around 4.8 or $5 billion has been fixed, but they found that there was a data breach from Yahoo site and data was leaked. So on account of that, there are various suits filed across. So the consideration has been reduced by almost $500 million. So during the process, during the legal due diligence, you will able to ascertain what are the claims or what are the threatened claims or what are the litigation currently the company is following up. So as I said, why it's important to ascertain whether any regulatory violations, to ascertain the ownership of the assets what the company claims. So you have the various assets. As I said, it's intellectual property or real property. When you talk about intellectual property, you have trademarks, and you have patents, you have copyrights, and you have other. Nowadays you have the data is the new oil. So many companies have the data which can be monetized, which can be capitalized. So how, what are the privacy laws the company is being followed? So you need to conduct a thorough investigation. How you will conduct investigation? What are the consents they have taken? What are the licenses they have taken? Whether they have the permission to further monetize, and they are the permission to further assign. So you need to make the checklist of this. Such how you do this entire thing, because you need to prepare entire checklist. How you prepare a checklist, because you don't know. For example, if you're taking a, working on a project, if the project appears, say in the, for example, it's a case of an industry, so you need to create an entire grid of application of the compliances, what are the laws it requires. Unless you have the entire checklist in your, unless you know yourself first what are the laws applicable to the industries, then only you can able to ascertain whether during the process of due diligence whether they have complied it or not. So in order to ascertain, make a master list, list out the all the applicable laws. Nowadays you can search in Google, but otherwise you can read the industry reports of the particular industry, and if you require, you can also write to the authorities and asking for the entire compliances. Of course, we have our panel advocates, our solicitors who can guide us. But if you want to conduct your own diligence, then you, this is the way the process. You need to make a centralized grid where you can list out all the applicable laws, regulations, and the compliances applicable to the particular industries. This what happens, then when you have the entire grid list on your hand, then you can get the entire landscape of this industry, as well as you also come to know that where this industry and where this target company is falls into that particular landscape. So when you identified these areas, then you need to look into the, again you need to subdivide. You can earmark this and function wise. Again you have the corporate. First of all, what is the corporate structure? What are the memorandum? Whether the company has the object, has the power to enter into the contract, whether the articles of association stipulates any kind of approvals, whether the board is competent, if yes, whether you require a shareholder's permission for that. It all depends upon, if it's a company is a listed company, then it's on under SEBI as well as the Companies Act, whether these compliances, whether companies and the board has been followed it or not. You need to make a checklist for this. Similarly, all companies when they enter into a transactions, especially in the commercial transactions, they runs into a number of contracts. Again, the contract runs into number of pages. So you need to examine this in case if you're conducting a diligence, if is acquisition of the company, as we are discussing in terms of acquisition of the company, whether the contract has the uh, right to for assignment, whether the contract has a provision for assignment, whether the contractor is an exclusive supply or it's a non-exclusive supply. If it is related to the group company of that particular target company, whether then the same terms and conditions will be given to the third party. So you need to examine all the terms of the contract. Generally it is observed that 20% of the contracts entire volume 20% of the contracts covers around 80% of the business. So first of all, you need to ask for the top 20 suppliers or top 20 contracts. Then you need to examine this, because it's not, sometimes it's very laborious process, not impossible but laborious process to review each and every agreement. So take the top 20 contracts normally, which is more than 70 to 80% each covers this. So examine this, clearly list out if any onerous conditions which restricts, then highlight it, then discuss with, if it is possible, then also discuss with the particular supplier or vendor in case there is a possibility for amending this. If at all not amending, then there is a possibility for entering into the new contract when this acquisition happens. Similarly, you need to also look after the litigation. What are the litigations against the company? As I said, litigation can be, one is already filed, one is not filed. So, for example, I have observed in one case that there was a huge insurance claim was filed that has been shown, but during the process, that insurance claim was rejected by the insurance company. So, whether we need to see whether any unresolved insurance claims involving the company, or what are the potential civil liabilities during last 10 years. So if it is, suppose at lower level, at district level or at the high court level, if you won a case, there is a chance that matter can go to the appeal. So what is the probability and what is the possibility of winning that case? So how we need to earmark that claim along with the interest and other damages? What are the claims? What are the reliefs? Based on the reliefs, you calculate the claim, and then you also need to factor this in your consideration. Similarly, in case the cases are involved against the management or against the executives of the companies, including its directors, then you need to make this as a separate, because at the end of the day, directors are responsible for running the company. So in case of any criminal case against them, that definitely jeopardize the interest of the business. So you also need to ascertain the impact of the same. Similarly, in case of any regulatory orders, for example, in case of a PCB notice has come, whether withdraw the consent of operation, or whether they rejected the pollution control board license, PCB license, then what will be the impact? Then we need to identify what are the notices, or what are the notices come against the company from the regulatory authority. In addition to this, we also need to examine whether any settlements or mediations or any arbitrations going on against the company. And if at all, if it is already settled, then it is settlement has been signed, and a consent decree or mediation award has been, as an award has been passed and it was settled. You also need to check into that. Then your IP related litigation. In IP related litigation, maximum it happens in case of the software issues, because software is the license is granted, either it's a SaaS based or a on-site license or on-premises license. In case of licenses, whether there is an infringement, normally it happens that if they given X number of users, you are using Y number of users, then there will be a litigation. So you need to examine whether any kind of this litigation is filed against the company or not. Apart from this, you also need to take the list of contingent liabilities, and you also need to examine whether there is any provision, any possibility that against this contingent liability, any of the liability can come up over a period of time during the process of litigation. So you also need, these are the entire thing what you need to examine while conducting the due diligence. So again, when we are talking about the contracts, so see the termination clauses. Again, the major top 20 contracts, see the termination what are the exclusivity conditions, what are the clauses for the breach and termination. These will give an basic idea that in case the company would like to renew the contract, or company would like to enter into a new contract, then it will help the target company as well as the acquired company to negotiate the terms with the vendor or supplier. Now, coming to the legal risk, you also need to conduct a legal risk assessment. So, how you will conduct the legal risk assessment? Take the list of the entire logs cases filed by or against the company, and see that what is examine the what are the financial implication liability. Resort the summarize the entire liability and see what is the receivable and what is the payable in case the cases goes as it is in favor or against the company. Once you have this, then you need to figure it out, because every it may not be possible. You know that there are some cases where in PF or ESA government can wait up to 7 years for filing a case, for issuing a recovery notice. So what will happen is this transaction will cannot wait for 7 years. So what will happen, you need to fee earmark certain amount, say for example 5% or 10% of the consideration will be earmarked. In case any dispute or any claims comes up to this percentage, say 5% or 10%, it's purely depend upon the commercial negotiation. So that will be earmarked till that time, till the amount below 10% of the consideration the acquirer company will bear. In case any amount beyond 10%, then the target company or the seller who will make good of this loss, or not loss, good of these extra additional expenses incurred by the acquirer. So you understand this. Let's fix some amount, agree for this, because every time it's not possible to sit and discuss each case whether this how much liability will come or not. Take a commercial decision with respect to stakeholders and earmark for certain amount. Similarly, in case of any regulatory inquiry, it is possible to compound the case in case of any, say for example, a food safety issue. There are some 10 challenges were filed for say misbranding or misbranding or adulterated food. In that case, these cases can be compounded. There is a penalty from 3 lakhs to 10 lakhs. So ascertain all these cases and go and settle and compound this and pay make the penalty. So this is one way to address the issue. And another area is how to address is that simply, because most of the parties will not agree with this, but in case whatever the disputed amount, whatever the liabilities amount, that just earmark that amount, keep into an escrow account as and when the issue has been resolved. Then if it is in favor of the company, then release that amount. If it is against the company, then make the payment from the escrow account. This can also be uh, envisaged in the agreement, but normally it will be very difficult because other party will not agree, because he's selling the company because of money, so he will not happy with sitting his money parked in the bank. But there is a provision that we can do this kind of it, and we can transaction. So, lastly, about the employees and labor, this is the one of the area what we over a period of time. There are many due diligence part failure, because as per Harvard report, out of 10, 7 due diligence fails or 7 mergers fails. Why? Because out of this majorly on account of the cultural issues, because manpower is the one of the major area where we have to need to have a cultural balancing, cultural fit. The entire manpower of two different entities, they need to be merged into a single entity. In that case, the cultural integration has to be happened very smoothly. So one of the area is that to ascertain the key employees, who are the key employees, who are the critical employees, how these critical employees has been treating this in the targeted company, and what is the process of integration with the new company. This is very critical. You need to do this. And another area nowadays is about the data protections. Of course, we all know that there are a number of sessions has been conducted and protection laws under BNCLC itself. So, what are the process of data uh, utilization in the company, and what is the process and what are the purpose for this data is being processed, and what are the how the consent is being obtained, and these are being complained or not, and where it been stored, is stored with third party, it is stored on site in house. So these areas need to be looked into it. whether proper compliances has been carried out in storing this data, because you need to store the data very securely. You need to have a cmm level 5 security clearance, security compliances, and in case of any data breach, you need to, within 6 hours, you need to intimate to CERT. So all these compliances is very critical, especially after this enactment of DPDP Act. So data protections laws has gained a significant moment. And you know why? Because the penalty can go up to 250 crores. Imagine a company of 200 crores or 500 crores, if penalty is levied 50% of his net worth, then your entire process of conducting this due diligence and acquisition of the company, that will not yield the financial result what the, with an objective of conduct making this an effort to acquire the company. So that is very critical. You need to comply that. And lastly, you also need to examine about the sustainability. So nowadays, environmental laws has gaining significance. So what are the sustainability provisions the company is taking, especially in inclusion, especially in controlling the plastic, carbon, and other efficiency measures which can reduce the global warming. So these are the areas which we need to conduct for various due diligence in acquisition of the company. And another area is of the intellectual properties. So intellectual properties, we all know that there are various forms of intellectual properties. Your trademarks, many companies been identified, they have the distinct attain the distinctiveness and reputation over a period of time, and they gain the reputation of well known because of their trademarks. The trademarks because of their services and process. So this is the important asset. So what are the trademarks applications? What are the trademarks registered in favor of the company? Whether they have been renewed from time to time or not? Whether any applications are pending? And what are the infringement cases filed by the company or against the company, if any? So you also need to check all these cases. And in addition to that, what are the softwares the company is being using, and what are the licenses they have been given, whether these are the open source licenses or the proprietary licenses, whether the licenses can be transferred or not to a third party in case of, by way of assignment in case of any acquisition. Other area is about the domain names, because domain name is the important identity of the company, because nowadays cyber squatting is so prevalent that there are many uh, fake websites with the extension of the domains with well-known names will be created on different registries. So you also need to have the record and proper investigation of the entire names, the username. Mostly what happens is people forget to change the username and password, or it will be the particular employee. The moment the employee leave the company, then the username password will also goes with him. So again, you need to change in this name. It will be a cumbersome process. So whether this entire username, passwords, or all licenses, the keys, if you are having a source code, everything has been in the safe custody with the proper person, the safe custody. You all need to ensure the same. Then comes your the traditional and conventional real estate. So most of the companies have either own their property or they will have the property on leases. If they're owning the property, so again we need to go the conventional due diligence of verifying the title, whether the ownership has been properly transferred. In case of any transfer from the government, whether there is again the sublease or again again the transfer by way of assignment or by sale can be done or not, need to examine. In case of a lease properties, mostly in commercial properties, especially in the consumer oriented business, all the places, the retail spaces, etc., they are largely on leases, because they will open very fast. They'll, so that is the reason they'll take on the leases. So you need to examine the lease agreements. First and foremost, you need to see that the residue period of the lease, how long it is there. Because if lease is only for 2 years or 5 years, then after 5 years you need to hand over the premises, or you need to go for a renegotiation of the rentals. Normally in case of renewal, the rentals will be very higher. Otherwise it's a normal escalation of 5% or 10%. So you need to examine the residue period of the lease. As higher it is better. And also need to see whether, normally most of the leases it will be mentioned that in case of a transfer, in case of the transfer, then the lease will come to an end. So we need to see whether such a condition exists in the lease agreement. If yes, then you need to take the consent from the lessor. Then you need to take. In case if it is a license under easement act, then a license cannot be transferred. In that case particularly, you need to enter into a separate agreement with the owner of the license or owner of the property. Then you also need to examine the encumbrances on the properties. How you will examine? If it is a company, you go the register of charges, you examine. And if it is an non-company, if the property is on the name of individual, it's very difficult. But generally hard and fast rule is to just examine the original title deeds. Then otherwise, if original title deed does not available, it's a deem that it has been deposited by way of mortgage, mortgage by way of equitable mortgage, then where you can keep the original document and raise the loans. So this is the simple technique. If you have these documents, original documents, then it's a deem that yes, it's not been deposited elsewhere. So there is no mortgage, no charge exists on the property. Of course, there is a possibility that then if you can keep another set of documents, even mortgage can be created on a certified copies. And if the mortgager accept that, mortgagee accept that, it can be created on the certified copies also. But one technique is that at least you see the original documents, then you can rest assured that yes, it's not been mortgaged. So finally, all compliances will come to an end when you did your employment related compliances. So we initially we saw that various forms of due diligence are various kinds of due diligence. Under this we are doing a legal due diligence. Legal due diligence, why we need to do legal due diligence, what are the areas we need to look into it. And on we already come across the employment contracts and labor law compliances. But most importantly, what you need to keep in mind is that number of the employees and what kind of approval it is required from the respective government. If you normally it doesn't require, but some cases it requires an approval. Because in the change in the place from one place to other, in case of any transfer or in case of any effect in the unions, if it is a unionized, then it will definitely require a consent. So then you have the employment contracts. Normally all employment contracts will govern irrespective of the change of the same terms and conditions, or rather most favorable conditions. If the acquirer company has most favorable terms, then automatically they'll extend the same terms to the employees. But you need to see that whether the terms, in case if it is vice versa, then you need to examine the impact on this, because you cannot reduce the CTC or reduce the perks of the company, target company, but you need to match that you need to figure and factor into your consideration. So so to sum up this, there are various ways to consider conducting a due diligence, but one of the easiest way is to make a checklist of all applicable laws, and and examine this each line item with your observation. Examine, once you list out all the applicable laws and all the applicable regulations and all the activities, then examine with the actual available situation on the ground. then do an vulnerability assessment where you comprehensively identify the potential threats, considerably identify the liabilities and impacts, and how it can be having an effect on your consideration. So these we need to keep in mind. And with this, I'll stop here, and I'll request Mr. Vikas to allow the participant to raise any questions.
After you have explained so beautifully, there doesn't seem to be any question, except one had asked us as to whether this session would be available on the YouTube. We had said yes, it is available. And you have already taken up to the entire spectrum of this, understanding how that corporate due diligence is. I feel that once people watch it and hear it, and thereafter see the PPT, everything would be so self-explanatory. And thank you, Mr. Srikanth, for sharing your knowledge.
Thank you, sir.
Thank you.
Thank you.